They are both teachers and guides. While religion is the inner life of the spirit, law is the outer life of the community. A very good morning to esteemed dignitaries on and off the dais, distinguished audience members, the press and media. It is with immense pleasure and honor that I welcome you all to the grand inaugural ceremony of the 5th National Conference on Law, Religion and Society, a Constitutional Deliberation 2023, organized by KD Law College, Bengaluru. Another milestone in the growing repertoire of impactful events based on the theme of constitutional law. I am Shantini Rakshan. Muskan Mishra Chaturvedi and I are honored to be your hosts for this momentous occasion.
Before we commence the proceedings, let us seek the blessings of the divine. I invite Sushma, Isha, and Pragya to grace us with the invocation song to set the tone for the day's events. Join us in harmony as we embrace the spirit of togetherness through music.
गजाननं भूतगणादिसेवितं कपित्तजम्भो फलचारुभक्षितं उमासुतं शोकविनाशकारिणं नमामि विघ्नेश्वर पादपङ्कजं नमामि विघ्नेश्वर पादपङ्कजं सन्ततमहं कुञ्जरमुखं शङ्करसुतं तमिह श्रीविघ्नराजं भजे सन्ततमहं दन्तिसुन्दरमुखं मन्त्रताण्डकसुतं तमिह श्रीविघ्नराजं भजे श्रीविघ्नराजं भजेऽहं 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 भजे तमिह श्रीविघ्नराजं भजे श्रीविघ्नराजं भजे सेवितसुरेन्द्रमहनीय गुणशीला सेवितसुरेन्द्रमहनीय गुणशीलं जपतपसमाधिसुतवरदानुकूलं भावितसुरमणिगण भक्तपरिपालं भयङ्कर विषङ्गमानन्दगुणहारं श्रीविघ्नराजं भजे श्रीविघ्नराजं भजेऽहं 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 भजे तमिह श्रीविघ्नराजं भजे शनककेयूरहारावळी कलितगम्भीरगौरगिरिशोभं कामादिभयभरितमूढमदकलिकलुषकण्ठितमखण्डप्रतापं सनकशुकनारदपतञ्जलिपराशरमतङ्गमुनिसङ्गरसलापं सत्यपरमाञ्जनयनं प्रमुदमुक्तिकरतत्त्वमसि नित्यनिगमाधिस्वरूपं श्रीविघ्नराजं भजे श्रीविघ्नराजं भजे श्रीविघ्नराजं भजेऽहं 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 भजे तमिह श्रीविघ्नराजं भजे श्रीविघ्नराजं भजे श्रीविघ्नराजं भजे
Thank you. That was indeed a soul-soothing rendition, reminding us of the power of unity and the purpose of our gathering here today. Now, I request our respected principal, Professor Dr. J.M. Mallikarjunaya, to kindly render the welcome address.
Good morning, all. Most distinguished dignitaries on the dais, delegates of the National Conference, organizing committee members, volunteers, and student friends. As a part of our continued tradition of hosting the annual National Conference in Constitutional Law, we now present to you the current academic year conference on the theme Law, Religion, and Society, a Constitutional Deliberation. In India, like elsewhere, Constitution is our holy book, and we follow constitutionally ordained religion called secularism. Secularism represents, in a true sense, the synthesis of reason and compassion. The spirit of tolerance, universalism, and freedom is the quintessence of secularism in India. The secularism, being one of the strands of constitutionalism, is meant to ensure orderly political coexistence that does not admit of according preference to or allowing domination by any religious, social, or political groups. It is an institutional arrangement that provides protection to a reason-based polity as against polity-based religious doctrine. And it stands for application of rule of law in the realm of religious freedom. The state, by using secularism both as sword and shield, is in continuous struggle with religion today. In a constitutional sense, the state is secular, but there is no imperative for individuals and communities to be secular. Rather, there is a freedom, fundamental freedom of religion. That freedom often has been the source of hope and despair in India. The interplay between law, religion, and society is well accommodated within the Constitution of India, but the approaches adopted with successive governments to operate the interplay always varies. The interplay has been used and abused by the people at the helm of affairs, religionizing the politics, politicizing the religion, secularization process, reforms in personal laws, nexus of terrorism with religion, etc., are the issues which involve the intricate relationship between law, religion, and society. In such a situation, the state is faced with certain constitutional challenges that are sensitive. To ponder upon the issues that arise in the interplay of law, religion, and society, the present conference is organized. Over 40 paper presentations by the expert academicians and the enthusiastic students. Over 4 plenary sessions and 4 technical sessions that are spanned over 2 days from now. The deliberations are scheduled. Over 500 students offline and thousands of beneficiaries online shall be attending the deliberations. For this auspicious occasion, I now take this opportunity to welcome the honorable guests and the gathering for this program. At the outset, while I express my deepest gratitude for accepting our invitation to inaugurate the conference, I wholeheartedly welcome Honorable Mr. Justice Kaushal Jayendra Thakurji, Judge, High Court of Allahabad. Welcome to you, sir. I request Ms. Ankit Anand to present a floral bouquet to Justice Kaushal Thakur. Thank you, sir. It's my honor to extend a very affectionate welcome to Honorable Mr. Justice Subhash B. Adi, former judge, High Court of Karnataka and former Uplayaka Ayukta, Karnataka. Ms. Gauri Tarana shall present a sapling to Justice Subhash B. Adi. Thank you, sir. I also take this opportunity to extend a very hearty welcome to our beloved Professor Dr. V. Vijay Kumar, former Vice Chancellor, NLIU Bhopal. I request Ms. Nandini to present a floral bouquet to Professor Vijay Kumar. Thank you, sir. Sri Prabhulim K. Nawadgi, Senior Advocate and former Advocate General of Karnataka, has been our mentor and the guiding spirit at Kerala Law College, always in all our academic endeavors. Sir, I take this opportunity to extend you a very warm welcome and request Ms. Soundarya to present a bouquet to sir. Thank you. Dr. M.R.K. Prasad, Ms. Muralidharan, and all the resource persons of the plenary sessions, chairpersons of the technical sessions, also have joined us for the inaugural program. A very hearty welcome to you, sirs. I also extend a very hearty welcome to the registered delegates, paper presenters in the conference, organizing committee members, student volunteers, and all my dear student friends. I welcome you to the conference and wish you all a very joyful learning experience. Last but not the least, I welcome the members of the media, print and electronic, and all the invitees to the conference. Thank you.
Thank you, sir. It is my privilege to extend a warm welcome to our respected principal, Professor Dr. J.M. Mallikarjunan. I now request Ms. Sharmila H.S., Assistant Professor, to present a sapling as a token of respect. Thank you. I now request Dr. Anita M.J., Vice Principal, to introduce our guests for this event.
Good morning, all. Respected dignitaries, Honorable Dr. Justice K. Jayendra Thakur, Judge, High Court of Allahabad, Honorable Mr. Justice Subhash B. Adi, Chairman, State Committee, National Green Tribunal, former Judge, High Court of Karnataka and former Upalokayukta, Professor B. Vijay Kumar, former Vice Chancellor, National Law Institute, University, Bhopal, Shri Prabhulinga Navali sir, Senior Educate and former Educate General, Professor Dr. J. Mallikarjunan, Principal, delegates from all over India, resource persons, media, staff, and dear students. Today, I am extremely privileged to introduce Chief Guest of today's function, Honorable Dr. Justice K. Jayendra Thakur, Judge, High Court of Allahabad. Honorable Justice is graduated in law from Gujarat University with first rank and has done LLM in commercial law, securing scholarship from UGC. His Lordship is awarded with PhD in environmental law from Gujarat University. Honorable Justice has joined Bar in 1987 and practiced in High Court of Gujarat in labor, service, constitutional, civil, and criminal matters. His Lordship has always interested in academic activities and served as guest faculty in law colleges of Allahabad. His Lordship is also been a resource fellow with Gujarat State Judicial Academy as well as National Judicial Academy, Bhopal. His Lordship has also attended several national and international conferences and also written several articles which are published in reputed journals. In Feb 1997, Honorable Justice was appointed directly as District Judge. On May 4, 2013, His Lordship was appointed as Additional Judge of High Court of Gujarat. And in 2016, Honorable Justice was transferred to Allahabad High Court as Additional Judge. And on March 13, 2018, Honorable Justice was appointed as Permanent Judge of Allahabad High Court. At present, Honorable Justice is also pursuing postdoctoral studies on compensatory jurisprudence from National Forensic Sciences University under Padma Shri Dr. J.M. Vyas. With these words, I present Honorable Dr. Justice K. Jayendra Thakur, Judge, High Court of Allahabad. to this August gathering. Now I request Ms. Rashmi, faculty, to continue with introduction of other dignitaries on the dais. Thank you. Thank you, ma'am. It's my pleasure to introduce distinguished Honorable Mr. Justice Subhash B. Adi, born at Sankeshwara town and Belgavi district, completed his education at Sankeshwara town, graduated from JSS Law College, Hubballi. After completing law in 1977, Sir joined the chamber of the then designated senior counsel, Sri S.C. Javali, who was one of the first 5 designated senior counsels after reorganization of the states. Sir was elevated as a judge of High Court of Karnataka in 2006. Sir, as a varied experience in legal profession, handled constitutional, civil, criminal and educational matters. Sir has appointed as a Apollo-Koikta in 2013, conducted extensive public hearings and inspections. Up to 7,000 complaints were disposed of by public hearing. Sir was designated as senior counsel by Honorable Supreme Court of India in November 2018. Appointed as chairman, State Monitoring Committee for Solid Waste in Karnataka by National Green Tribunal in 2019. Nominated with then Chief Justice of Karnataka as the chairman of Fee Regulatory Committee for Professional Courses. Sir heads high-level committees for review of the issues relating to the demand for reservations of various communities. Sir's varied experience in the legal field has seen him periodically training the newly recruited judicial officers at Judicial Academy of State of Karnataka. With these brief introduction, I present Honorable Mr. Justice Subhash B. Adi to this August gathering. I take this privilege to welcome an eminent academician, administrator, and a founding faculty of National Law School of India, University, Bengaluru, Professor Dr. V. Vijay Kumar, former Vice Chancellor, National Law Institute, University, Bhopal. Sir has several academic accomplishments to his credit: BA and MA in Political Science, MA in Public Administration, ML in International and Constitutional Law, MPhil and PhD in Law from the University of Madras. Sir began his academic journey as Assistant Professor at the Presidency College, Madras in 1978 and joined the National Law School of India, University as a Senior Assistant Professor of Law in 1988. Sir specializations in Constitutional Law, Administrative Law, Human Rights, Law of Elections, and Refugee and Humanitarian Law. The various academic and administration positions at national and international level held by Professor Dr. V. Vijay Kumar stands testimony to the immense contribution in research capacity building in the field of law. Sir was a Vice Chancellor of Dr. Ambedkar Law University, Chennai, Vice Chancellor of National Law Institute, University, Bhopal from 17th May 2018 to 31st May 2023. He administered the United Nations High Commissioner for Refugees Chair on Refugee Law, the Chairman of Undergraduate and Postgraduate Council, and also the Registrar of National Law School of India, University between 2005 and 2008. Sir was a member of Karnataka State Higher Education Council, Bengaluru till 2016, visiting professor at the University of Passau, Germany, and visiting scholar at the York University, Toronto, Canada. An exchange visitor at the National University of Singapore, member of the Board of Governors of the Ancient Law Institute at the Singapore National University. Sir was also designated as the Deputy Chairperson of Ancient Law Institute in 2009. Sir has several publications, 50 plus more, in national and international journals, as well as chapters published in several international books. He was one among the 6 experts at the Michigan Colloquium, the development of Michigan Guidelines on Internal Protection Alternative, organized by Professor James C. Hathaway at the University of Michigan Law School, USA in 1999. Sir was one among the 3 project leaders to study the impact of armed conflicts on children in East Asia and the Pacific region jointly with UNICEF and the Center for Refugee Studies, York University, Toronto during 2002 to 2004. He was one among the 2 Indian scholars selected by the United States Information Agency as an international visitor to participate in a program titled The Living Constitution in June-July 1988.
He was one among the two scholars selected from India as a fellow at the Salzburg Seminar on American Law and Legal Institutions, Salzburg, Austria, during 1993. Apart from this, Sir has several awards to his credit for distinguished service rendered in the field of law, both at international and national, to mention a few. The Amity Academic Excellence Award with Amity Global Business School 2011, the Best Vice Chancellor Award 2011-12 at 63rd anniversary of the Geneva Conventions Day in 2012 by the Indian Red Cross Society. The Vijay Gupta Award for Services in the Field of Law at the 27th V.K. Sinha Foundation ceremony in Bhopal on 14th February 2022. He was privileged to find the honorary mention in the Forbes Legal Power list in 2022. The Overseas Friend of Indian Award for the services in the field of law in India at the House of Lords on 25th May 2022. With these brief introduction, I present Professor Dr. V. Vijay Kumar to this august gathering. Now, I take this privilege and opportunity to introduce yet another distinguished personality very close to our institution, Sir Prabhalin K. Navatki. Sir Prabhalin K. Navatki, designated Senior Advocate, former Advocate General, Government of Karnataka. Sir has previously served as Additional Solicitor General for the High Court of Karnataka. His family is a legacy of people serving for the legal fraternity. Sir is the son of Justice Shri K.B. Navatki, Judge of High Court of Karnataka, who has served Indian judiciary for a period of 27 years. The grandson of Shri B.K. Navatki. Sir graduated law from University Law College, Bengaluru, a very dynamic mutta, and has stood first at university law examinations. Sir started independent practice in the year 1994 and has set up a law firm employing 20 to 30 plus advocates as colleagues. The youngest Additional Advocate General appointed for the state in Karnataka in 2011. Sir has practiced in various fora including High Court, Supreme Court, commissions, tribunals, quasi-judicial authorities and tariff fixation committees. Sir as designated as Senior Counsel by the full Court of Karnataka in June 2014. Is a pioneer in infrastructural laws in the country, especially in the field of electricity in the post-liberalization period. Handled several issues relating to Constitution of India, particularly in the formation of elective governments and local self-governments. An expert in anti-money laundering law, has credit of several matters argued and reported in several law journals which are precedent-setting cases. He was a standing counsel for the Karnataka State Board of Work for 12 years. Is a member of Karnataka Lingayat Education Society and the chairman of governing board KLE Law Institutions. Sir has also represented the interest of Union of India in several cases in international commercial arbitration. To mention a few, it is on Mauritius, represented oil petroleum products with Mauritius before the High Court of Karnataka, ICE. He has addressed various lectures in several legal institutions, ranging from constitutional law to the challenges faced by the legal profession at international universities. Sir has delivered lecture on comparative constitutional law at University of Salford, United Kingdom. Sir is also was invited by University of Paris for delivering lectures and was invited to chair the session on overreaching of executive power in 2017 in Sydney. Sir has also delivered lecture series organized by British Council of Indian Transformative Constitutionalism in various universities in the United Kingdom, including the University of Warwick, Exeter and Newcastle. With these brief introduction, I present before you Shri Prabhalin K. Navatki to this august gathering.
Thank you, ma'am. I now request our esteemed chief guest, Honorable Dr. Justice Kaushal Jayendra Thakur, Judge, High Court of Allahabad, to inaugurate the 5th National Conference on Law, Religion and Society, a constitutional deliberation by lighting the lamp. I request our other dignitaries to kindly join him. Everyone, please rise for the occasion.
ಕನ್ನಡದ ದೀಪ ಹಚ್ಚೇವು ಕನ್ನಡದ ದೀಪ
Thank you all. I would now request our chief guest and other dignitaries on the dais to kindly release the conference compendium. I also request Dr. Manoj Kumar V. Hiremat, IQAC coordinator, and Ms. Sharmila HS, conference coordinator, to kindly join.
Thank you all. I now take this opportunity to request our chief guest, Honorable Dr. Justice Kaushal Jayendra Thakur, Judge of the High Court of Allahabad, to kindly render the inaugural address.
Namaste, Suprabhatam. Good morning. I began with Sanskrit. Why? I'll tell you the reason after I start with the regular formalities, because I would not like to be blamed that you have changed the trends of the speeches. So my esteemed senior colleague from the Karnataka Judiciary, Justice Subhash Adi, a judge par excellence, Professor Ujain, who needs no introduction. Despite that, mirror was shown to him that these are your achievements which we are telling these young people. The young advocate general, the vice chancellor, the principal of the college, all my young student friends for whom I am here, who will be deliberating on this important issue for the fifth time. And I was intimated day before yesterday by Professor Sir, would you be able to come? I said that I am not a student of socialism. I've never been. Because one thing which my grandfather, post-independence, taught me was the constitutional casteism. This is what he forecasted in the year 1960 to my father, which has come to me, because I belong to the family of lawyers. That constitutional casteism one day will be blamed by this society. I don't delve much into it. But that is what we are facing today. Now to go to the subject first, why did I begin with Sanskrit? Most of you must, this is for the young blood. You must be seeing the TV or your Google or whatever. Because some of them are seeing it right away also, putting their heads down on their mobile quotas. which is given to them by the government. इतना तो करना ही है दिन भर में. Otherwise, you will not get your bread and butter. So this is a social change. You don't sit with your parents, but you sit with your mobiles. If we go back to the dark ages, we had nothing. We had nothing. I still remember my first committee meeting when I was a young judge. I just walked into the judiciary, and one of my senior judges told the computer people, "What are you talking about computers? We don't even have what is known as electronic typewriter in my court. What computerization?" So we have come right from there till today. Do you call this a social change? No, this is, according to me, not a social change. It is what I call a technological change, which has done bad to a society or good to a society. The times will tell. See, today you are glued with your gadgets more than you are glued with your family, which was not there when we were students. This is a change. Yes, society has to change. I am not delving on the other issues of whether we should have uniform civil code, not have, because that will be part of your deliberation for 2 days. And I would not like to delve on that issue because, according to me, when the framers of the Constitution thought it fit to keep it in the chapter 4, not in the fundamental governance, then what is the purpose of deliberating on it right away? Because in those days also, if you go by the constitutional debates, if any one of you are interested, it's available even on the Google. The constitutional debate goes to show that Dr. Ambedkar Sahab was one of the forefront runners for advocating uniform civil code. And I, I'm nowhere near great survive, but I still advocate the judiciary at times oversteps itself when it goes to what is known as judicial legislations. They are permissible. But at the same time, we should remain within our limits, which are subscribed by the constitutional itself. What are the constitutional ethos? As I've been regularly telling, see, everywhere you don't need constitution. Were there no courts before 1950s? Were we not having any courts? Were we not having any legislations? Were they so anarchical, then why did we not give away them? We still have the CPC code, which is 1908 code, with all the amendments as they suit us. Looking to our social changes. We even have our Evidence Act, which is 100 years back. CRPC. There are so many laws. And I personally believe that every time this issue of uniform civil code comes, it's more on the political agendas rather than having any social or religious backgrounds behind it. The minority feels it's because if it's for our operation, the secular people feel that why should we have that when India is a secular country? Secularism is tolerism. You have to be tolerant. You can't say that I will put on this dress only when there were uniforms prescribed. Maybe I don't delve into all those because my ideas about secularism are quite different, which I don't want to raise here in the podium. See, army has its own rules. Does anybody speak there? You ask any army man, what is your caste? This is Indian. What is your religion? Indian. Bharatiya. That should be the spirit of the religion which we are having. Why do you want to have uh, multifarious litigations about whether the mosque existed, not existed, the temple was there? Why can you not live in harmony? That is what I would put it. The have-nots today were have-nots in the dark ages also. The gap is getting wider and wider. It's not my saying. I'll just give you one small anecdote about constitutional ethos not being applied in all kind of situations. Say, I'm posing this question to all of you. Maybe there may be difference of opinion. Say a husband and wife go for a movie. The married life is about 4.5 years. They have a young kid of 1.5 years. They come back. The couple doesn't stay in Gujarat. They stay in a state where there is no prohibition. So the husband has a beard. At night, when the child goes to sleep, as usual, he demands. The wife refuses that you are inherited easy. And in fury, he slaps. In fury, the wife goes to the police station to lodge the complaint. The Thana in charge calls the husband, tries to specify the situation. I had a gentleman who told me that what about her constitutional rights? This policeman should be suspended immediately. Unfortunately, I was a young judge. Now I have grey. Out of lot of I gathered energy and asked him, Sir, does the social pattern of the constitution want that the lady with a 1-year-old child should go back to her paternal home, file all those litigations which the lawyers will teach her, which after 1.5 years she will dream. Is this what had happened in my family life? And then she'll start repenting. No. The gentleman again said, what about her constitutional ethos? So in my anger and fate, I said, Sir, what are you talking about constitutional ethos? The constitution says that the family should be maintained. You don't have to break families. Under the pretext that a right as a woman, a right as a woman is to nurture the child. The child needs both of them. Then there'll be fight for getting the custody of the children, of the child. Do you want all that under the guise of constitutional ethos? The answer is no. According to me, you may differ with me. See, you have seen the rituals, the beginnings. We in India still believe that our old traditions should not die away. I had a very funny litigation before a few days. And I didn't know that this is cropping up now in India also. Maybe I am on live law also. The lady says I'm in live-in relations with X. Please give us protection. I said, yes. The Supreme Court says you have to be given protection. He gave her protection. Why? Because they both were married. Their family did not want them to get married. She was afraid that there may be what is known as honor killing. So we gave her. So one on the other day, the other petition comes seeking similar relief. I said, who is this respondent number 4? My lord, he is the husband of the lady. He is the husband of the lady. Why have you come here? Well, he is arresting her. And so she wants this protection. She is in live-in relations. I said, fine. And the argument was that under the constitutional mandate, even Kasab was given legal protection. I said, fine, I'm ready to give you legal protection. But on one condition. Please show me where the lady has filed criminal complaint against her husband. No, my lord, that is not there. So you want a certificate from the High Court to go to the trial court and show, sir, I'm being harassed by my husband. 498 have been lodged. Are the High Courts meant for that? Does our social or religion permit that under the constitutional ethos? Means the division bench said no. We said, yes, we are not against live-in relations, but we are against this adulterous live-in relation. We cannot certify this. Yes, we would have protected her, definitely. We gave protection that she will not be harassed if she files all the complaints if she so desires. My time is running. I'll tell thanks to the principal, sir, for having thought of me as we had met at the criminology conference in Gandhinagar. I'm really thankful to be in Bangalore, where I can get guidance from Justice Adi because I'm doing my postdoctoral thesis, and I would request Professor Mulidharan. Many of you don't know, I have appeared before him as a young student when he was my moot court judge. Please, Mulidharan. I learned what mooting is when I first appeared before him in the year 1985, and then again in 86 at Pondicherry. I was as young as you are, and he was younger to me, not in age, but in mind. He still has that ability. Thank you for being here. Thank you, and I wish that this deliberation which go will bring some changes in the present litigations which are going on, the legislations which are there, and the government of India and the government of Karnataka would benefit from this deliberations. Thank you.
Thank you, sir. I would now request our keynote speaker, Professor Dr. V. Vijay Kumar, former Vice Chancellor, NLIU Bhopal, and founder teacher of NLSIU Bengaluru, to kindly render the keynote address.
Mr. Justice Kaushal Jayendra Thakur, Honorable Judge of the Allahabad High Court, Mr. Justice Subhash B. Adi, former Judge, High Court of Karnataka, former Upalokayukta, and Chairman, State Committee of National Green Tribunal, Mr. Prabhuling Nawadgi, Senior Advocate and former Advocate General, my friend and colleague, Professor Mallikarjunaya, the principal of this college, Dr. Anita, the vice principal, my former colleague and the founding member of the National Law School, and my table tennis partner, Murli. I don't want to call his full name. Professor M.R.K. Prasad from Savgaonkar Law College, my former colleague Vishnu Prasad, my learned colleagues of this institution, KL Law College, my dear young students, invitees, ladies and gentlemen, a very good morning to everyone present here. Any discussion on the theme that is assigned, law, religion, and society, a constitutional deliberation is likely to create a spark in the discussion, for or against. And about 40 papers are to be presented during the student deliberations. And therefore, comfortably and conveniently, I would like to lean away from the judicial decisions because not many will be discussed, deliberated, dissected, and I do not want to do that. But as a student of law, as a student of political science, as a citizen of this country living with different religions together, I would like to discuss or inform you of how law, religion, society, the constitution, they're all intertwined in such a manner. Something becomes open that we see. Something may not become open, but will continue to remain for long. I would like to just give you the anecdote. I was in the York University. I co-taught a couple of courses in Oxford and also at the Center for Refugee Studies at York University. Immediately after the Godhra incident, there was a conference held, and there were many Indians who migrated to Canada. They were all holding different positions in various departments of the university, different universities. They all assembled together, and they were all speaking ill of the system, that things go wrong. In India, it is what has happened. So many people were killed, so on and so forth. I waited for some time till the question and answer session was open. I had a paper clipping with me. I took it with me when I attended the conference, and I connected two issues together. The September 11, where the Twin Towers were brought down, and then nothing was visible overtly, but covertly, the way that the Americans have gone into different countries arrested and detained many people and took them to Guantanamo Bay, and the way that they have treated those prisoners, but for the intervention of ICRC, I don't think they would have been released. So that continued even for ages. And I just read out that paper clipping which I had in my hand, that after 3 days of this conflict in Gudra, normalcy started returning, and possibly you would see a Muslim driver, a Christian conductor, right? A mixed population traveling by the public transport system confidently without any fear. And that is possible only in India, nowhere else. Because in all the religion, all the communities, there are elements. It has no religion. The nature of the human beings, they're all wired like that. If they don't burn a bus, they can't sleep. If they don't hit a stone at a bus or create something, they can't sleep. And that such people are there in every religion, so you can't blame religion for this practice. Right? And therefore, when I mentioned this, they looked at me as if I'm a strange animal coming from somewhere. Is that a reality? Right? Possibly if I walked into New York City, in fact, I was there in New York City when the Twin Towers were brought down. The next week we drove down. Possibly if they had seen any Muslim individual, right? The way they were looking at each other, things would have been worse, right? That did not happen in Godhra or in Gujarat or in any other place. And that is one aspect which I wanted to flag. So we have conflicts, and that is why India lives in its diversity. Unity in diversity is a slogan that we used to say, and that is what we used to market. And we know how many Western countries are investing billions of dollars in trying to understand what this multiculturalism is. Right? They can learn, they can write theses, they can write articles. But unless and otherwise, they imbibe the qualities, they internalize those qualities of multiculturalism, I don't think education would do anything better. I have a different view. When I was a student, we had friends from all the religions. If it was Christmas, we used to go. I have gone with the groups in carol singing, right? You can't believe that. And we have gone to different mosques, and we used to go to different places. When there is a Muslim festival, we will be invited, and we are vegetarians basically. But still, they will cook separately and keep it. Even today, in Bhopal, we followed that. The festival, I think India is the only country where we have got too many public holidays for festivals. It is only to bring in the concept of brotherhood, inviting each other, so that if there is a Muslim festival, they used to invite, we used to go there. It's not only for eating, it is exchanging pleasantries, right? When we went to sing, carols, right? Before Christmas, it is not that we wanted to be converted to some religion. I don't become converted to because I go to somebody's place. So these are all the things where you balance very well, and universal brotherhood that we speak of in all human rights documents will remain a distant dream if you don't internalize these values. Right? I think that is a point I would like to drive home. Having said this, as a student of history, political science and law, we have seen, and particularly this topic, I was going through one of the articles, which will be possibly presented. The opening statement in the abstract is very, very attractive. I thought I would read that out and then start my proceedings. The role of religion in politics, but I added society, right? In society and politics, is a complex and dynamic area of study that explores the influence of religious beliefs and values on political ideologies, policies, and decision making
process. Throughout history, religion has played a significant role in shaping political landscapes, with religious institutions and leaders exerting influence over governance and social order. Very beautifully written by a writer. I don't want to disclose his other name. I thought I'll take the clue from here and then go back to history, the ancient part of history, whether it is Greek, Sparta, Athens, or whether it is our own civilization. I think we all worshipped God in different forms, right? And that is why if you look into the Greek gods, there are different gods for everything. For love, there is a god. For message, there is a god. It's part of their culture. You want to call it as a religion? Wonderful, you can call it as a religion. Or you want to be in between religious culture? Wonderful, right? We have come to all these things, but what we have seen immediately after the dark ages, that the Western countries have usually, which is dominated by the Christian religion, created a theory which we teach in political science and also in social contract. The 5 students will be very happy to note about this. The evolution of the state, right? The theory, and the theory that we call it as a theory given by Sir Robert Kilmer, divine right theory or divine origin theory. How did this happen? It happened because the people, before we came into a civil society in that format, they feared lightning, thunder, rain, right? And somebody used this opportunity that somebody is fearing this, and therefore possibly we should get the obedience based on this. And then the king came up and said, if you don't listen to me, this is the curse of God. The king has not seen the God. Right? The king started telling that this is the curse of God and therefore you shall obey me. If you obey as if the king can stop the rains, the king can stop the thunder and lightning. Right? It is a natural phenomenon. But that natural phenomenon, which the individual was not able to, face it or suffered it, thought that there is some reason which the king is claiming, so let us be obedient to the king. Right? And therefore, the king became the representative of God on earth. The king became the representative of God on earth. And this is not necessarily the Western notion. If you carefully read the Tamil literature, there is a lot more that we can understand. The only difference between the Western notion of the king, who claimed himself as the representative of God, or I think Henry VIII went to the other extreme to claim himself as he was the state. Right? He was the state. He was not even as the representative of God, but he himself was the state. A subtle difference, I won't call it a subtle, a deep difference between the Western notion of that monarchy and the Indian system was the king was not above the law. He may be a lawgiver, but he was never above the law because the king was also subject to the concept of dharma. Which the Western notion said, no, he is a representative of God, he is the fountain of justice, he is the lawmaker, he can do anything that he wants. And therefore, one can see that the obedience, and that is how the society came into picture, traditions came into picture, and then slowly but steadily, the dominance of religion in the affairs of the state grew beyond reasonable control. And then it led to a conflict between the temporal power on one side, the religious power on the other side. the Pope versus the King, right? And this conflict continued for a couple of centuries. Before, in some places, the temporal authority won over, in others, the religious authority won over, right? This is part of history, I don't want to get into it. But I think the Western thought, the philosophy of Niccolo Machiavelli came into existence, and see, he was the one to describe the popes as the profligates. I don't want to define what profligates stands for. You have the Google, you can search for it. And call the popes as profligates, diluted the authority of religion, right? And that is why you call that as a period of Renaissance. Change. From the blind faith that you had in the king, you started questioning the authority of the king. And then that was very well used by the representatives of the people, the parliamentarians. And then between 1600 to 1688, what we saw was the conflict between the temporal and the representatives of the people, we the people, right? And ultimately it culminated in the glorious revolution of 1688 in England, and then there is no looking back, right? And can you also believe, today we are talking about religion and community, the society and the law. In England, when the Act of 1701, Act of Settlement was enacted, there is a ban that no Catholic can become a king or queen. Can you believe it? No Catholic. It is not inter-religious conflict, intra-religious conflict. No Catholic can become a king or a queen. Right? So these are all things that we learn through history. And when you come to the ancient documents that we have studied, I made a reference to Tamil literature, where the king who goes for hunting comes back to ask whether you have copious rain in your state, in the state that he was the king. Which means that is an indication of a just society, that the gods have blessed the state with copious rain, and so that agriculture will flourish. Industries were not there, right? And when agriculture flourishes, the king also is very happy because the people are all involved in some avocation or the other. That was the first question he will ask his minister: did they get copious rain? Right? And similarly, the Sibi Chakravarti's story that we read, where the dove comes and falls on the lap of the king, the emperor, and he said this is his dharma to protect whoever sought the abode. It is nothing to do with religion, but something which stands above the king, and the king was willing to give part of his muscles cut up from the thigh as to weigh the weight of that dove, so that he could give it to that vulture which was chasing it. And ultimately, you just see that the gods of justice come and say, no, this is only a drama, and cure everyone of all those things. These are all stories through which we understand that somewhere something is totally connected with the governments. And if the governance can go wrong, I think nothing can go well with any form of government that we may have, whether it is democracy, tyranny, oligarchy, or whatever form that we call. Having said this, the English philosophy of the divine right theory developed to its most extreme logical conclusions during the political controversies in England. I told you about 14th, 15th century and the 17th century. Sir Robert Filmer was the founder of this philosophy, right? Who are also called as the Royalists, holding that all Christian kings, princes, and governors derive their authority direct from God. Derive their authority direct from God. Right? Whereas the parliamentarians said, no, it is a social contract. We derive the authority from the people. So two extremes. And therefore the democracy flourished. And I think after 1688, the Glorious Revolution, there was nothing for the British people to look backwards. The monarch has become more of an ornamental authority, right? Except cutting the ribbon and laying the foundation stone of some building, the king has very little power or public visibility in any sense. Now, I would like to connect and take you, as I mentioned to you, I'm not getting into all the judicial decisions. I may refer to one or two opinions here and there. I will not get into it because the paper presenters will, curse me for having, exhausted their way of deliberations. But I would like to be little different, and make all the youngsters sitting here. We have not gone to the classroom. I've been teaching constitutional law. I've been a student of constitutional law for 45 years. In the law school, we created a culture that if you have to get into the class, you shall have the text before you. Every student will carry the text. When we mention a particular article, they will turn the pages, they will start reading, somebody will, start following it. If you don't do that, possibly you think and take sides with what the government is doing, whether it is run by Congress party or BJP or Communist party. I think all are the same flock, right? Except the party, I think they are in the art of governance, right? And somebody, when I was a student of political science, what is politics? Somebody asked this question. And the beautiful definition, which I cannot forget, not for the examination purposes, but something which I cannot forget, the definition came forward. Politics is the art of gaining power. Is an art of gaining power and the science of retaining it. Right? It is an art of gaining power, and so everyone will do that. Right? So you can't correct them. And probably because of this, the father of politics, Aristotle, defined democracy as the worst form of government. As the worst form of government. Calling democracy, I don't know, Aristotle's name. Right? Is there any issue with it? I would like to take you. Before we look into the text of the Constitution, the content of each and every article, can you hear me at the back? Yeah, better, right? Okay. Right. Now I think
Sir, your phone is ringing?
I don't have a phone.
Yeah, then fine. That means this is okay. Sometimes. Speaker has to be on.
Okay, I think.
If you switch off that and use this.
Right. Okay. Right, Aristotle called it as mobocracy. Yeah, democracy described it as mobocracy. Can you hear me? And is it audible?
Just put off that mic and give another mic. Speak. Use this. Use this mic.
Right? Okay. Now, today, than ever before, the Supreme Court is frequently using the concept of constitutional morality. I would like to take this opportunity to place before you my understanding of this constitutional morality, and every one of you will understand and appreciate what I'm trying to say. That's why I said I will not get into the judicial decisions. Now, of late, the phrase constitutional morality was used in diverse sense by the court. I will not get into it, but that prompted me to get to the Constituent Assembly debates. When I went through the Constitutional Assembly debates, there is one place possibly where Dr. Ambedkar used the phrase constitutional morality, but in an entirely different context. Right? I don't see the relationship between that phrase being used. And the judges of the American Supreme Court started using that constitutional morality concept, and maybe the Supreme Court of India also followed it a little later. In one of the earliest definitions of constitutional morality, which was given by Grote, which he described as a form of supreme obedience. Please carefully listen to me. Grote defined this constitutional morality as a form of supreme obedience to the various aspects of the constitution of the land. Not to the God. Not to the God at all. Whether which God you believe is immaterial. For us, Constitution is the Bible, Constitution is the Quran, and Constitution is Bhagavad Gita or any other epic that you would like to refer to. And therefore, Grote's observation is very clear that it is supreme obedience, not ordinary obedience, supreme obedience to the various aspects of the constitution of the land. Was it right? I just add on to this. According to him, constitutional morality implied certain obligations for both the citizens as well as the authority which have been enlisted below. So he identified 4 of them. The first one is respecting the constitution and all forms of authorities deriving the command from the constitution. Second, availability of right to freedom, right to free speech for the citizens to criticize and hold accountable all those officials acting in pursuance of their constitutional duties. You must be really careful when you are doing that with reference to the judiciary. Right? Third one, it doesn't mean that you should not critique. Criticize is different, critiquing is different. If you are able to give reasons and tell, if a judge comes across your understanding and your observation, possibly may change. The Harvard Law School journal brought out by the students, the first ones to read the journal or the articles, are the 9 sitting judges of the American Supreme Court. Why? If the students are given some very good reasons to critique their judgment, and if the reasoning given by the students is better than what they have put it as a judgment, they look up for the next opportunity to overrule their own judgment. Because law is not constant, it is changing. Today my opinion may be X, tomorrow it may be Y. Right? And therefore, we have to look at these aspects as well. The third one is the obligation mandated of authority and public officials to act well within the sanctioned charge given to them by the Constitution. And finally, people contesting for political power and their opposition should have reverence for the Constitution. Right? all the three bodies, executive, legislature, and judiciary, they're all creatures of the Constitution. And who gave this Constitution? We the people. Please read the preamble any number of times. We the people, that is how it starts. And finally it says solemnly resolved to adopt and to give ourselves this Constitution. And some of the millennials like you ask this question. When the Constitution was drafted, I was not even born. So I'm not part of that we. Right? When the reference was made, when the Americans were celebrating their second century of their Constitution, I was there and one of the senators, a black American lady, a senator, made a mention and she put it very beautifully. I can never forget that statement. She said, when the Constitution of the US was adopted, the term we, in writing that we, they have forgotten to include my name. They have forgotten to include my name. The treatment meted out to the black, the racial discrimination. And if it is a woman, it is even more worse. White or black, it makes no difference. Right in those days, that things have changed. And things are still changing. Right? No state is perfect in any sense. If somebody says it is perfect, lucky is a state where there is only one religion. Right? Today, I think I would put it this way. Lucky is a state where there is only one religion. So there is no conflict. Right? In Tamil Nadu, there is another group, atheists. They don't believe in any God. They also survive. But they cannot say they are not part of the Constitution. They are also part and parcel of the Constitution. Therefore, ladies and gentlemen, and my dear students, please look at the phrase, we the people. And Edmund Burke very beautifully responded to the questions that are likely to arise. When the Constitution was drafted, I was not a party to it. He said, state is nothing but a partnership agreement. A partnership agreement of those who lived and gone with those who are living and those who are yet to be born in this community. It is a continuity. It is a continuum. So when we say we the people, my name is not included, the moment you get a birth certificate, you automatically become part and parcel of the we. And therefore, when we have adopted and given ourselves this Constitution, don't you think that we have the duty, and that's what Groth said, right? Very beautifully, it is supreme obedience. We have created this Constitution, we have given this Constitution to ourselves, we have created these institutions, and if you pass a law, if you pass a command, it is my duty to obey. Right? And therefore, again in political science, I take a reference that what is your right? Where does the liberty begin and end? C.M. Joe very beautifully put it. I have the liberty to swing my arm, right? Very freely, till I find another man's nose. Right? The moment I find another man's nose, then I should safeguard my own nose. Therefore, no right, no liberty is without any limitation or a restriction. And therefore, we need to understand, and that is a place where I would like to invoke the apathy that we have towards Part 4A. Part 4A, which because in jurisprudence you must have been taught about Affeldian analysis, right, duty, all those things. We are too good in speaking about our right, whether with our parents, with our brothers and sisters, right? If it is property issues, much more, right? But we seldom speak about our duty, right? Please wake up, ladies and gentlemen. India is a soil where the entire society developed not on the basis of rights, but on the basis of duties. On the basis of duties. Thomas Hill Green, he wrote way back in 1934 in Oxford, lectures on political obligation, right? And he defines this phenomenon very beautifully. I have not seen a better writer than Thomas Hill Green. He puts it that in the performance of everyone's duty, please carefully listen to this. In the performance or the discharge of everyone's duty, everyone's right is automatically protected. Everyone's right is automatically protected. On the contrary, today we are all trained to speak about our rights, forget about our duties. I'll come back to the concept of right and duty a little later. Now, when Ambedkar used this phrase, constitutional morality, I need to tell you the context in which it was raised. As to the accusation, this is what I've taken from the Constituent Assembly debates. It's not my own, right? I just pinpoint what Dr. Ambedkar had said about his constitutional morality. As to the accusation that the draft constitution has produced a good part of the provisions of the Government of India Act 1935. Right? Many people say it is a replica. It's all right, but we the people have finally adopted and given to ourselves. It is not by the British Parliament. Right? I make no apologies. Not me, it's what Dr. Ambedkar said. There is nothing to be ashamed of in borrowing. It involves no plagiarism. It involves no plagiarism. Murli will be very happy. Nobody holds any patent rights in the fundamental ideas of a constitution. What a beautiful statement. Nobody holds a patent. Just because you have written. And sometimes patent also we don't follow. I read many of the judgments of the Supreme Court and High Courts that India is not a federal country because it uses the term union. Right? We are not as federal as the US Constitution is. I don't know what constitution they have referred to. Right? Please read the preamble of the American Constitution. We, the people of the United States of America, in order to become a more perfect union, in order to become a more perfect union, we have created this federation. That is the object, it's not to be achieved. Federation is only a tool. And here in the Indian Constitution, we have given union. It doesn't mean that it is quasi-federal. We don't want to be a doubting Tom. So this way, when you look at it, you put it very beautifully, there is nothing to be ashamed of in borrowing. It involves no plagiarism. Nobody holds any patent rights in the fundamental ideas of the Constitution. What I am sorry about is that the provisions taken from the Government of India Act 1935 relate mostly to the details of administration. 1935 Act doesn't give you part 3. 1935 Act does not give you about part 4. Right? The directive principles or the fundamental rights. It doesn't give. The moment we have given to ourselves Article 32, the right to knock the doors of the Supreme Court, the highest court of justice in this country, directly without going through the other courts, and that is why we call it as fundamental rights, right? I think we need to understand our duties as well before we ask for our rights. And he went on to say, I agree that administrative details should have no place in the Constitution. I wish very much that the drafting committee could see its way to avoid their inclusion in the Constitution. But this is to be said on the necessity which justifies their inclusion. And then he refers to growth. And let me also put it this way. American Constitution is a very brief constitution having only 7 articles. But all the 50 states have their own constitutions. And if you place one above the other, I think it may be taller than this podium. And therefore, we need to take something from the Government of India Act, nothing wrong in it. And he referred to growth, the historian of Greece, who said, and this is quoted by Ambedkar, and you will find it in the Constituent Assembly debates. The diffusion of constitutional morality, not merely among the majority of any community, but throughout the whole, is the indispensable condition of a government at once free and peaceable. Since even any powerful and obstinate minority may render the working of a free institution impracticable without being strong enough to conquer ascendancy for themselves. By constitutional morality, growth meant a paramount reverence or reference for the forms of constitution enforcing obedience. I will not read this in detail. So, constitutional morality gives a duty on the governed to obey supreme obedience to the authority concerned. It doesn't mean that, please also look at what Mahatma Gandhi has said. You shall have the right to agitate against unreasonable laws. Right? If the law is unreasonable, don't obey unreasonable law. But that resistance must be within the four walls of a civil society. Not to the extent of burning the buses, breaking, right? The public property, the private property, so on and so forth. And therefore, constitutional morality, as I understand, is that the people of this country also have an obligation, right, to obey. And at the same time, all these authorities who claim the powers within the provisions of the Indian Constitution should also respect this constitutional morality, right? And then finally he says, refers to the history of Europe that I referred to earlier, gives an ample and appalling testimony to this fact. The other is that the minorities in India have agreed to place their existence in the hands of the majority. In the history of negotiations for preventing the partition of Ireland, Redmond said, now this is all, it's not my own, these are all embedded in the history of the Constituent Assembly debates. Redmond said to Carlson, ask for any safeguard you like for the Protestant minority, but let us have a united Ireland. Carlson's reply was, damn your safeguards. Damn your safeguards. We don't want to be ruled by you. Right? No minority in India has taken this stand. They have loyally accepted the rule of the majority, which is basically a communal majority and not a political majority. See what crystal clear ideas that Dr. Ambedkar had. Whether the minorities will continue to or will vanish must depend upon the habit of the majority. Will depend upon the habit of the majority. The moment the majority loses the habit of discriminating against the minorities can have no ground to exist. They will vanish. Without mentioning any religion, without mentioning anything, Dr. Ambedkar has very beautifully brought this. Right? And please look around geographically. In the entire South Asia, we are the possibly only secular state. Right? We have not declared, in spite of the fact that we had the Hindu majority, we are very careful, we never declared this as a Hindu state, Nepal did earlier. Right? All other states, Buddhist states, Sri Lanka and Bhutan, Islamic states, Pakistan, Afghanistan, right? Bangladesh. So there is nothing wrong in it. That is the way they want to, but there is nothing wrong in it. They also have a constitution. Right? Right, I'm sorry. Okay. Right, I have a couple of other things. I have received a check that my time is up. I'm going to begin actually. So this is the problem with the teachers when they give the microphone, right? To seldom take back. Right. Okay. So these are the implications of what you call it as we the people. Please don't read it as an ordinary English phrase and forget it. We the people conveys everything, and we have given the Constitution. If we don't respect the Constitution, then I think the end is written very beautifully on the wall. And then there is some article written by the Canadian teachers about treating Canadian constitutionalism, claims to understand religion as a culture. Religion as a culture. And therefore, the theory of accommodating, and that is when if you go to many of the Western countries, you have in Toronto, way back in 2003, 2004, 174 languages were being spoken in Toronto alone. Because people from all walks of life, from all across the globe, they have migrated to Canada, right? So they're also looking at Canadian constitutionalism looks, right, to claim and understand religion as part of its culture, right? So that is the argument which I wanted to discuss. And I have I would like to just take a few minutes to quote our Justice Kadzur. Justice Kadzur, as the judge of the Allahabad High Court, not as a judge of the Supreme Court, but as the judge of the Allahabad High Court, he wrote an article, and the title of the article is very clearly on this: Law, Religion, and Politics. He observed in this article the whole progress of mankind has been from ignorance and helplessness before natural and social forces to understanding of these forces and harnessing them. Therefore, the basis of religion is ignorance. The basis of religion is ignorance of the real nature of these forces, the thunder, lightning that I referred to earlier, right? Helplessness before them, and the fear of the unknown. The fear of the unknown is a God. The fear of the unknown, that the God will punish me, the God will do this, God will do that. Thus, for example, many of the Vedic gods, he refers to Agni, Surya, and Indra, were personification of natural or social forces. These forces could either benefit man or harm him. Thus, timely rains could benefit agriculture, right? And that's why, I told you in Tamil literature, whether you have copious rain, it was only verification of the way that the king was governing, but he puts it in a different format, right? If timely rains could benefit agriculture, but failure or delay of rain could ruin the crops and ruin administration also. He didn't say that, but I'm just adding that. And whether there would be timely rain or not was entirely beyond man's control. Possibly when he wrote this article way back in 1986, there was nothing. But I think Tamil Nadu also invented something called as cloud seeding. They can also bring rain by clouding, seeding the cloud, right? Indra, who had to be propitiated to save oneself from this wrath, right? That's one way of looking at it. Then he referred in detail that smallpox that people used to get, and even today in the 21st century, if you just go to villages, if you are in an urban city, it's difficult to see nowadays, but still, right? There is a mosque in Malapet, right? You just go and see, morning, about 200 people with a child, with the children in hand, they will all stand in queue. When after the prayer, the Muslims come out, right? They just bless them, just blow on the face. It's a belief, right? And therefore, this smallpox was also believed to be that of the wrath of God. But over a period of time, science was able to prevent smallpox, right? That the fear of God with regard to smallpox has by and large diminished. You don't worship God, just no, you don't want to get the smallpox, right? That he referred to very beautifully, and he refers to all scientific developments. And as science develops, the day will come, right? That finally you will not believe in God, you believe in rationality. You believe in rationality, right reason. But maybe Justice Kadzur was not correct in one sense, because Karl Marx, when we studied Karl Marx, when they climbed a tree to see where the God was, that story, they climbed on top and finally they saw. So this philosophy also saw God there finally, which is also wrong. And today we also see the end of science is religion. Kadzur argued in the beginning of science is end of religion, but there is a theme which is also running parallel. End of science is religion. End of science is religion. And then he was absolutely right when he quoted, religion was not abolished by the American, French, or Russian revolutions. In fact, religion cannot be abolished, but will wither away gradually with the progress of science and social development, and will disappear completely when man is no longer helpless before natural and social forces, but is able to control them. What these revolutions however, did was to relegate religion to private affairs unconnected with the state. Unconnected with the state. But is that a dichotomy possible? I don't think so. I don't think so. And that is why I use the phrase that they are all intricately interconnected. Right? Law, state, society, constitution, laws, authority, governance, they're all intertwined. And therefore, I would not like to get into the rights, the concept of secularism in the preamble, all those things I will avoid. And then finally, thus we see our constitution is modern and secular. However, the fact remains that while our constitution is modern, our social order is still backward and semi-feudal. Is still backward and semi-feudal. Since in feudal or semi-feudal society, religion has a powerful hold on men's minds. Sometimes it may also include women's minds. The vested interests seek to exploit this situation by perpetuating and accentuating caste and communal divisions and by sowing the seeds of discord among the people. Right? And therefore, I would request all the students not read part 4A for the purposes of your short notes question in the constitutional law paper, but carefully read at least some of them. I would revert back to my seat after reading out these three fundamental duties. Article 51A, it shall be the duty of every citizen of India, E, to promote harmony and spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversities, to renounce practices derogatory to women. That's one part. F, to value and preserve the rich heritage of our composite culture. Let me tell you, ladies and gentlemen, the foreign countries, Western countries, they are looking at India as a very good example of this composite culture. But what we see today is something against it. What is happening in Mizoram, right? Though it is not a conflict over, but it is still happening after the 3 months. Also, it is still continuing. The third one, most important for the youngsters, to develop scientific temper, humanism, and the spirit of inquiry and reform. These are all our fundamental duties, but are we able to follow that? I would like to cite Chinnapareddy, Justice Chinnapareddy, as it was. In Vijay Emmanuel versus State of Kerala, I think all of you would remember the judgment. And just 2 lines of Justice Chinnapareddy. Our tradition teaches tolerance. Our philosophy preaches tolerance. Our constitution practices tolerance. Let us not dilute it. Let us not dilute it. And therefore, today we have a huge challenge. The challenge is the social media. Anyone can mischievously write something and float it. Right? I hope you have not forgotten about 6-7 years ago when social media, was sent across mobile phones against the Northeast people. Within 2 days, people were vacating, the railway stations, airports, they were all filled with people to vacate this place. So this is a huge challenge, and please, without verification, do not act. Even with verification, don't act, because you are not to act. There are laws and legal institutions that will take care of everything. And finally, before I conclude, as a student of political science, I went to one of the best libraries in the Presidency College, built on, proper Burma tea group, right? And I was reading Plato's Republic. In those days, people never used the ballpoint pen; they used the ink pen, right? Somebody who had read this book, Plato's Republic, on the first page he has written something. I thought, I have not forgotten this. It is embedded in my, mind. Right? I read it once What a beautiful statement. Whoever is written, his name is not there, but the quote is very, very beautiful. Right? I would like to stop with this quote. People fight for religion. People die for religion. People do everything for religion except live for religion. Thank you very much.
Thank you, sir. It is now my privilege to request our guest of honor, Honorable Mr. Justice Subhash B. Adi, Chairman, State Committee, National Green Tribunal, former Judge of the High Court of Karnataka, and former Upa-Lokayukta, to kindly address the gathering.
Honorable Justice Jayendra Thakur, Judge par excellence and great academician, perhaps very few doctorates on the judicial side, and the combination of the judicial mind and academician mind has made the judiciary easy, and perhaps his judgments are more throwing on the social justice system. Just now you heard Dr. Professor Vijay Kumar, who elaborately explained the concept of constitutional morality, ancient history, and his vast knowledge when he was introduced. Except the name Vijay Kumar, rest of all were only achievements. On the dais, my friend Justice Prabhuling Nawadgi, one of the great lawyer, and coming from a great lawyer's family, had an occasion to practice before his father also. Principal Mallikarjun, eminent academicians and professors of the dais, dear students. Indeed, it's a great occasion. Firstly, I mentioned that I'm not an academician, I'm not a scholar on anything. I happen to be a judge, retired, and doing some work. Perhaps the topic chosen for the conference is very, very important in the present circumstances. Law, religion, and society. Religion is playing a very important role in the society. But if you go back the ancient history, religion originated for the human good. When there was no scientific development, when there was no orderly society, the religion brought the orderly society, social reforms, way of life. And that was the object. Over the time, how the religion developed, there were intra and inter-religion claim of supremacy. Intra and inter-religion claim of supremacy brought the conflict, distinction, discriminations, etc. This led to division in the society and percolated even today also. This division of society, then it is the religion dominated in some part of the country, some part of the world, and religion becomes the main tool in the hands of the administration also. Now, if you look at the various countries, whether it is Roman who followed the Greeks, whether Islamic or so many other countries, India is one country, perhaps there is no other country in the world having such a complex society. Complex society is that numerous castes, numerous religions, numerous language, numerous culture, numerous behavior, numerous tradition, customs, name anything. It's such a complex society, which is otherwise you will not find in other countries. But as mentioned by Mr. Vijay Kumar, 1935 India Act did not provide any fundamental rights or the directive principles, but for the administration, this constitution was made. But it was a very difficult task for the Constitutional Assembly to draft a constitution for a country like in India. Unity in diversity. You need to blend everything. I will give an example. Now, if you look at the religion which are referred to ordinarily in Indian concept, we have Buddhism, Jainism, Parsis, Islam, then Hinduism, and others are part of Sikhs also. But in certain legislations, certain Hindu laws, if you look at the definition of Hindu, Hindu is independently, it is not described as Hindu. Hindu, it takes into fold. It takes into fold Buddhism, it takes Jainism, it takes, and the Sikhs also takes. Perhaps the way of life in all these religions is the unique. But if you look at the tenets of the various religions, none of the religion preached bad for the society. The way of life was taught, but it was dependent on the circumstances when the religion was originated. Now, the concept of this conference, social change is what you need. What should dominate? Whether the religion should dominate or the society should dominate on the religion, or the law should dominate on the religion. Now, in the context of society, of our country, which needed a perfect document for the administration. Now, if the 36 long period and numerous persons debating on each issue hundreds of times, I may mention, thinking and rethinking and bringing about this constitution. And if you look at the constitutional preamble before amendment, to make it is a strong democratic country, it is not easy to make a strong democratic country. What was necessary? If you have too many religions, too many castes, too many languages, too many regional feelings, how to bring it all people of one, make them as one country and one nation. This was the task. The first principle of the Constitution was state has no religion. If you keep this in the mind, then debate on this, then you will understand. Now, what are the principles? Amongst all other principles, the basic principles, not the basic features, the basic principles on which this constitution stands. Basic principles are, first principle is the equality, that no man is above. Everyone has a right of participate, equality before law, equal opportunity. Then the liberty. Everyone has a liberty. Of course, there are restrictions, liberty. Then the fraternity. These are the three. Now, each one is interdependent. You cannot have a fraternity then without liberty, then without the equality. Equality cannot live without the liberty. So there is a blending of all this and essential character of the Constitution. Now, this is the basis for social, political, and economical justice system. To bring this in force, a strong debate went on, and we got this, the Constitution. Now, equality, if you look at Article 14, it doesn't discriminate anything. It only says equal opportunity, equal participation, equality before law. Nothing else. Then part 3 contains you have two provisions, the Article 15 and 16. What does it say? No one can be discriminated on the ground of religion, race, other things. So the religion has no part at all in the Constitution. Constitution brought equality. Constitution brought this state without religion. And Article 27, if you look at that, also says where any institution funded by the state, there is no religion teachings. So the religion is kept separate, independent, with rights. Article 27, if you take, Article 28, you take, all these things. The framers of Constitution had taken all care to ensure that there is a one nation, one country. Now, for one nation, one country federal system. Now, over the time, the state has no religion, but practically, what the religion should be the subject to the Constitution, or the Constitution should be the subject to the religion. Now, Article 13 defines the law. The law is, it may be by notification, by the rules, or by the statute, whatever, all the laws made under the Constitution. Article 246 of. Now, with all this background, now the various judgments have come. Now, in 1976, Constitution gets amended by 42nd Amendment. Insertion of the secular, insertion of socialistic, these two things come. Now, what is secular? The secular is that the harmony of the people, that there is no discrimination on the ground of religion. For all Indian, if you look at the the judgment of S.R. Bamai, 1993 ACC, and if you look at the S.S. Bala's case, integrity of the nation was the hallmark for the existence of our country. Now, I just now mentioned Article 51A and Article 51E, A capital A, small e, which requires fundamental duties. The fundamental duty is the live in harmony. Now, the Dr. Ambedkar, B.R. Ambedkar's in the debate also, when the debate was on the question of the fraternity, the one simple two words mentioned was, it is a meaning of that is, it is a common brotherhood. It is a common brotherhood. Now, what is required? Over the time, though religion has a right to exist under Article 25, each one has a right to profess practice of his own faith. That does not mean the faith should take the dominant position over the law or the society. Each one has a right of his own way to practice without harming. And every such an article, Article 25, is also subject to law. Now, this is the area where there is a need. Today, we want a strong democratic country. What is democratic country? That country ruled by people. Now, the people are ruled by elected representatives. Now, over the time, the electoral system and the diversity is now by means of this influence of the religion, whether really we are getting a democratic system. Now, is this electoral system, which ultimately is likely to govern and make this, the state has no religion, and if at all there is a mixed or the influence of the religion on the administration, what would be the effect of that? Now, these are the issues which need to be debated. I do not want to go in detail because the time constraints and other things. But Many times Supreme Court has said, what is the meaning of fraternity? And what is the meaning of society or social justice? How a society should exist in correlation with the religion. Now, what would be the effect of a law on the religion? Now, you may be feeling, or it may be in the public perception, that today there are some institutions dominating the rule of law, because the strong democratic country is dependent on rule of law. If the rule of law is a hallmark for a strong democratic country, then we may need to know what extent the religious freedom should be there, what extent the law should prevail over the religion. Now, the Constitution is a supreme document for the country, and a Constitution alone should prevail over all of things. Now, there are so many issues are coming day in, day out, and rights of a people, right of a privacy, so many things are coming before the Supreme Court and the High Courts also. And we are experiencing the difference and difficulties. And you may be knowing it also. Empty number of cases are pending before the Supreme Court on the question of interpretation of various articles of the Constitution, and pending for the decisions also. Now, social changes, when the society gets changed, for example, what was mentioned by the previous speaker, referring to the Kajju's article, Justice Kajju's article, the science, development of a science is bringing a social change. Yes, there is a need for it. We need to change ourselves from one stage to other stage. So, the social needs have to be, the religion has to be correlated, and it should go along with the social changes. For example, the Hindu law, what it was, uncodified Hindu law, what it was there before 1956, and after 56, how this was codified and brought in by legislation. And for example, when I was interacting with the judicial officers, I was mentioning one provision. Today, there are many legislation which needs to change, because the social change has made the different legislation in order to keep the orderly society as per the demand of the time, not as per the tenets of something or religious feeling. Now, I will give one of the issue which is still there in this statute book. For example, in the Hindu maintenance and guardian and maintenance act, the Minority and Maintenance Act, there is a provision for the guardian, appointment of a guardian. Now, who can be a guardian? The law says, up to child, 5 years of the child is the mother, and after 5 years it is the father. And no mother cannot become a guardian after that. Now, can it be said that today's world, woman is incapable of being a guardian? Now, this is where the social change is necessary. Now, the woman can go to the moon, woman can work for any such the position. Now, the President of India herself is a woman coming from a tribal community. Can she not become a guardian? Similarly, there is also a provision for a Hindu joint family who can be a Karta. It says only male member can be a Karta, male elderly member. Can it be accepted in today's world? Can a woman cannot, when she became a judge, when she can become a president of India and she can be head of the country, can he not become a manager of the family? Now the social changes are the need of social change. Law has to change according to the social needs. Religion has to blend with the social changes. So if we want to have a country as of one, within diversity of so many things, we need to bring such a law which will govern all the sections of the people equally and give equal opportunity equally. That is the hallmark of the Constitution. Equality, without the equality, we cannot exist at all. and exceptions are created. For example, now the exceptions, if you find in the Article 15 and 16, it doesn't refer to the caste or the religion. It doesn't refer. It refers to the class. Exception is a class, not the religion caste. But over the time, we brought it caste as in a class. It doesn't mix this. Mix the social need, not mix the complex of the caste or creed. Otherwise, what the idea with the constitution was brought to make India as one nation and harmonious living in a brotherhood. It will be difficult because day by day, numerous castes, numerous divisions, numerous religious feelings made likely to divide the society and destroy the fabric of strong democratic country. There is a need to debate on all these issues to bring a solution that what is necessary for the country to have a strong democratic for the people, by the people, to the people, and then only it is possible. Otherwise, if you think that it must be for the religion, for the society, then it is not possible. So I do not want to take your time because only 15 minutes, principal said we take only 15 minutes. Then I said yes, because we have already overcrossed. But my feeling, what I found, my general observation, I am not an academician to speak about much, but my feeling, my thinking of the Constitution, one of the best document we have, but only to understand and social needs. Sociological change is necessary, and that change can be brought as per the time demand. Now, the science is developing, technology is developing. The woman, for example, one of the example is single parent. Now, what are her rights? These are not there. If you go by custom, then there are a lot of difficulties. If you go by the present existence of the law, they will not help. So the social change needs, the law has to change. So for the society, if the law is to be made, what is required for the today, to people to live in harmony, in brotherhood, as per the constitutional essence, then we need to debate on these issues and bring about a solution that makes the country as one and everyone feel must that I have a right. Right is for all the benefit that the country will elicit. Thank you very much.
Thank you, sir. I now request Mr. Prabhulim K. Nawatgi, Senior Advocate and former Advocate General, to render the presidential address.
Chief Justice Kaushal Jain, the Judge at the Allahabad High Court, Honorable Justice Subhash Reddy, former Judge of the High Court of Karnataka. The keynote speaker for today's function, Dr. Vijay Kumar, the beloved principal of KLE Law College, Professor Mallikarjuna, members of the staff, Professor Muralidhar is there, my friend Mr. Jan Chinappa, Senior Advocate, is there, and most importantly, dear students. I am here more as a host than a guest. I have been associated with the KLE Law College for the past 20 years. And it is always a pleasure to come back again and again to the institution. As much as I have now become a permanent fixture on the dais whenever Mallikarjuna calls me. I must say that one of the great art rather, the last speaker of function should develop is to understand the patience level of the audience. And from the body language, I must know that I must keep it very, very short until the patient runs itself out. More particularly because I am preceded by some illuminating discussion on a very complex and sensitive subject. I have attended many seminars, symposiums, but what I heard today from Professor Vijay Kumar would always remain with me as one of the most memorable lectures on this topic. Honorable Justice Thakur and Honorable Justice Subhash Shari have shared their own experiences on as judges presiding over various cases touching upon the constitutions which relates to these subjects. We are grateful on behalf of the institution and behalf of the society that they have come here and enlightened all of us on this very complex and sensitive subject. But when I was sitting here, I was more than the topic of today. I was reminded of that occasion where we had all assembled, including Professor Mallikarjun, at the inauguration of this auditorium. Possibly it was in the year 2016, when Mr. Arun Jaitley was here to inaugurate this audience. I very distinctively remember what he said, and I would like to share that with you. He said, the greatest strength or the future of a country like India is its economic resources. And the greatest strength of economic resources is human resources. And the greatest strength of human resources is its youth. And it is the youth of the country which is the greatest strength and future of this country. So when I look upon all of you here, I see the future of India very, very bright. The future of this country is in your hands. I always tell this to all my students here. But on a lighter vein, I must say, I must compliment Mallikarjun that he's been able to keep the students so much packed into the auditorium. 30 years back, we all used to very religiously go to the college, but never to the class. And most of the symposiums, when Professor Coutinho used to hold it on, possibly Saturdays, we all used to stand outside, not come into the auditorium until the principal used to come and make us come into the auditorium. And as soon as we found the lecture of the speaker too long, we used to start clapping so that he would complete his lecture. I don't know whether he will invite me again so that I'm misleading most of you today. But these are the most beautiful days of your life, this lives of being students in college, particularly law institutions. Today, of course, the law institutions which we studied and the law institutions today, there's been a huge difference. Law institutions are no longer classical lecture classes where teachers teach law, but they are nerve centers of thoughts, ideas, and policies. And these seminars, symposiums like this, act as that catalysts for you, all of you, to think on these subjects. So the subject is not the subject which they have chosen is not a subject which has some finite conclusions or easily deductible logical conclusions. It is a great debate by itself. And as practicing lawyers, I must share, you don't get occasions much where you deal with these situations, particularly law and religion and law and society. For whatever reasons, as Advocate General, I did handle two very sensitive matters which very deeply went into this question of law and religion. The last of the arguments I did as Advocate General was relating to I thought I must just share it with you before I end. A particular situation which arose in the state of Karnataka. A very prominent and influential, much belonging to a particular community, the pontiff or Vetadipati, was taken into judicial custody. The question before the government was, the government received a lot of petitions as to what should happen to the mud. It had hundreds of crores of rupees worth immovable property. It used to practice several religious activities. The question which came before the government was, what should it do? What should it do to the mud? A lot of disciples, prominent people of that community came to the government and requested for its intervention. They sought my advice. And we directed a retired IAS officer to take over the administration of the march. Then that was challenged before the High Court. And the High Court was then debated on this question as to how far the state can enter into the precincts of the administration of a religious institution. What is secular activity of a religious institution? What is a religious activities of a religious institution, etc. were debated upon. The matter is still at large before the division bench. But that was a great experience, I must say, in which we dwelt at length on this subject. For all students, I'm sure we have a number of sessions which are going to follow up. I'm sure most of you would be enlightened by these sessions. Before I end, I must say this, the question about states' policies or relationship with religion is presently pending before the larger bench of the Honorable Supreme Court in revisiting Indian Young Lawyers Association case, which is nothing but Shabarimala, where they want to reconsider even the principles enunciated in Shirur Mutt's case. The Shirur Mutt case is considered a legus classicus insofar as law and religion is concerned, which was dealt at length in Shabarimala case, which itself is being reconsidered. To all students of law, I must say, please read Shirur Mutt's case, delivered by none other than Chief Justice Mukherjee, and then the latest judgment of the Honorable Supreme Court in Indian Young Lawyers Association, very erudite judgment by Justice D.Y. Chandrachud. These judgments will give you a bird's eye view of the present topic. As I said, I'm grateful that the institution invited me today and spent some time with all of you and to hear these very erudite and illuminating lectures. I am sure under the stewardship of Mr. Mallikarjun, the KLE institution will grow more and more in the years to come, and the glory of KLE society will always be glowing for all time to come. Wishing each and every student here, once again, all the very best in their all the endeavors. I take care. Thank you.
Thank you, sir. I request Dr. Manoj Kumar B. Hiremat, Assistant Professor and IQAC Coordinator, to kindly deliver the vote of thanks.
Good afternoon all. Respected dignitaries, honorees, and authorities. I consider it as my privilege to do a pious duty of expressing gratitude. I profusely thank Honorable Dr. Justice Social Jain Thakur for inaugurating the conference and expressing his words of wisdom. Thank you very much, sir. I request Dr. Chetuprasad, Associate Professor, to present memento to Honorable Justice Thakur. On behalf of KLE family, I profusely express a great sense of gratitude to Mr. Justice Subhas B. Adi for being our guest of honor and addressing the students. Thank you, sir. I request Mr. Jain, Assistant Professor, to present a memento to Honorable Justice Subhas Adi, sir. On behalf of KD family, we are beholden to Professor Dr. V. Vijay Kumar sir for your unwavering support in all our academic endeavors and for delivering a keynote address. Thank you, sir. I request Dr. Mansuban, Assistant Professor of Political Science, to present the nominee to Professor Vijay Kumar sir. I, on behalf of KD family, remain indebted to Shri Prabhu K. Navatri sir for your guidance and support in all our academic endeavors and for presiding over the inauguration of the conference. Thank you, sir. I request Mr. Tanmay, Assistant Professor, to present the memento to Shri Navatri sir. We students and faculty members of the college are indebted to our principal, Dr. J. Mallikarjunaiah, for taking efforts to make us continuous learners through these kind of activities. Thank you, sir. I appreciate the efforts of the participants coming from the different parts of the country for joining the event with the zeal to learn more and more. I acknowledge the presence of Professor M.R.K. Prasad sir, Muralidharan sir, Senior Advocate Danshinappa sir, Rahul Mishra, and other dignitaries to the event. I acknowledge the efforts of all the members of the conference committee and student coordinators who have worked to make this event successful under the leadership of Ms. Sharmila. Thank you. I thank all my colleagues, students, and admin staff and technical staff for extending all necessary cooperation and assistance in organizing the event, and I thank present media. Thank you very much.
With that, we draw the curtains on this remarkable inauguration ceremony of the 5th National Conference of Law, Religion and Society, a Constitutional Deliberation 2023, organized by KD Law College, Bengaluru. We encourage you all to enjoy the rest of the conference, immerse yourself in the exchange of knowledge, and build connections that will shape our shared future.